the jury to believe this guy. Let me talk about it here with my guest for the day. Florina Altschuler is here. She's a criminal defense attorney. She is in Buffalo, I believe. Am I right? Are you still there in Buffalo?
Sure am.
Great. And Jeff Lax is here. He's in the New York area. He's a law professor. Welcome both. First time with me, and I appreciate it. And as always, I apologize. Jeff, let me start with you. What about the challenge of having a witness like this, who's he's a loser in the big scheme of things, but the prosecution would love for the jury to believe this guy in this case?
That's the goal. Obviously, the prosecution would like this testimony to be credible. Unfortunately, it's not going that way. His story doesn't match the story he told before he was incarcerated for these other crimes. And so the prosecution is asking all these questions, but then he's getting tripped up by the defense and being impeached, I think, very effectively in terms of there were guns after, but there weren't guns before. You spoke to the prosecutors about testifying here and a whole bunch of other things that are inconsistent. None of that means that this incident didn't happen. And, he's not on trial, certainly. But in terms of his credibility, certainly his story doesn't match up what it was before.
Think about this, Jeff, and I'm sure you use these real cases in your duties, teaching those crazy kids. You see a case like this where I think the jury is looking for a reason to find Billy Ray Turner guilty, and they may, because of that, look a little bit the other way from Jimmy Martin's kind of sliminess. He's there, he's admitted certain things that's put him in prison already, and now, maybe we look the other way that. In general, we might not like the guy.
Well, I think you're 100% right, and you see a theme here. He's trying to, really pump up and bolster his own credibility, or at least the prosecution is. And you saw that in two different areas here. Here in the immediate testimony, because he's talking about the fact that he's the low guy on the totem pole. He's trying to garner sympathy for himself. Now, the question is why? He doesn't really care, I think, about people liking him. What I think the prosecution and the witness here are trying to accomplish is that he felt comfortable coming forward with this story, the true version of the story, after he was arrested, only because he felt safe after he was arrested. Earlier in the day in testimony, he mentioned, on cross, they asked him, well, why did you come forward with the true version after you were arrested? And his answer was, well, now I wasn't in danger. And what he meant by that was, what he's trying to convey to the jurors is, I wasn't scared anymore that Shara or her co-conspirator were going to kill me. And so that's trying to bolster his credibility.
The patient's stepdaughter, who sounds like she's got a little medical background herself, maybe unfortunately gathered through the process of the death of her stepfather. Two questions come to mind as I watch this testimony. Let me start with you, Florina. It's the substantive question about this witness's testimony. This is not good for the defense if, in fact, it was a situation in which not much of anything was told to the family, including mom never told what was going to happen or potentially could happen with this palliative care.
Yeah, and this witness, unlike our hero from the other case, is pretty believable and credible and doesn't have a whole lot of reason to lie, except for maybe the civil lawsuits that are pending, right? There's probably about a million reasons in terms of $1 million to conveniently forget what was told to her if something was told to her. The issue is the problem is compounded by 13 other patients who are also dead at the hands of this physician. And so I think she presents credibly. I think she's going to be believed. And I think the fact that this wasn't communicated to her and was just done is evidence of intent on the part of the doctor without any consent from the patient's family.
Yeah, and I do think that can be a leap. And it's a great point that, maybe she has buyer's remorse, as it were, and she was told more than she's fessing up to now because she thinks it was a mistake. And now, after the fact, only thing she can do is deny that she knew as much as she did. Jeff, my question for you, procedural. So put on luckily I have a law professor here. She's really testifying a lot about what her mom did, what her mom said. How do we get that stuff in through this witness?
Well, can I just piggyback onto one thing my fine colleague said, because I think she makes such a great point, and I would be remiss if I missed out on commenting on it. What a wonderful point that what might be on this witness's mind is civil lawsuits to follow. And the reason why I think that's so important to bring up right now is there has been tons of testimony to the opposite of what this witness is saying about her mother, which is that the doctors and the nurses and multiple levels of doctors and nurses have testified to this, that the families were in consultation about all these things with Dr. Husel. So this particular testimony, yes, it's 100% damning for sure, but it flies in the face of a plethora of completely opposite testimony. Mind you, opposite testimony from the prosecution's own witnesses. This case has not been going well for the prosecution until this witness. But anyway, I'm sorry. I didn't mean to not answer your
I was
question,
going to
Michael.
object as non-responsive, but just generally, how does this real hearsay from her mom get in through this witness?
Well, unfortunately, her mother is no longer with us, so there is an exception to the hearsay rule when someone is no longer with us. And if there were conversations there that was a dying exclamation, that could be admissible into evidence. And there are other ways through medical records to get the same evidence in as well, which I think she's actually referring to with the help of the prosecution.
Very good. Yes, the unavailable witness exception to the hearsay rule. So everybody turn in your Scantrons, and we'll take a quick break here and come back. Casting. This guy's got he's got a future in the business. Jeff, what would we learn from this kind of prosecution witness? If you're using this guy as an example for a class, whether it be a substantive class, procedural class, whatever it may be, you run a piece of this. What do you tell them the class after they've taken a look at it?
Well, I don't. I look at it two ways in this situation. I look at number one, how is the jury going to perceive the witness? And I don't think the jury's going to get too down into the weeds about what he's lying about, what he's not lying about. So I do think that it's important for the defense to impeach this witness, and I do think they're doing it as well as they can. But ultimately, that's the best they can do, and I don't think it's going to be effective, because ultimately, whether this detail happened in the course of the crime or that detail happened, or even if he was more or less involved in the crime, is irrelevant. What's relevant was the defendant involved in the crime, and there is nothing being impeached here about the level of involvement of the person who's actually on trial, which is Billy Ray Martin.
Yeah, and there's always took a deal to minimize that, and the jury believes that this is really the bad guy, and they kind of give a break to the defendant in the case.
Well, that would be reasonable doubt. If you think that somebody else may have been the perpetrator, then that could be potentially grounds for legitimate reasonable doubt. But so far, there's been no evidence presented that the defendant was not involved. Nothing that's been impeached here, as I mentioned before, brings anything into evidence that suggests that the defendant was not involved in the murder. So far we're not there. But to your point, yes, if the defense can actually bring it to the level that they're starting to think he was more involved than the defendant, then you get into reasonable doubt territory if they can do that. But that's a long battle.
So it seems to me to do. In the meantime, let me chat with Florina and Jeff. Jeff, prior to this trial, back in the summer of last year, the ex, Shara Wright, was trying to get out from under her plea deal. Talk about buyer's remorse. She claimed, I think, ineffective assistance of counsel. What's your take on how often that happens and how successful it is or isn't?
I don't think it happens very often, but keep in mind, this is somebody who created this elaborate cover-up scheme, and that's why this case went cold for so many years. So this is someone who is a fraudster, quite frankly. And so does it surprise me that when someone like that will, change their mind continuously about their strategy, about their legal strategy, about their approach to the case, about even pleading? It doesn't surprise me. But listen, when you're on trial for your life, literally, you'll do anything, right? And that's why I think I'm so interested in seeing her. We're going to really find out the entire landscape of this case a lot better once we hear her testify, if she does in fact testify in this case.
Yeah, I would expect some major attitude there. Maybe not so casual. I think that 30-year sentence seems pretty good compared to against life or death. Maybe she should have consulted some sort of financial advisor when she came into this money. I mean, obviously, I wish I could see what she spent $1 million on in 10 months, because that takes some doing. Jeff, I hope we see her too. What would you expect her to do that Mr. Who's the guy we had on here minutes ago? I forgot his name already. Martin. Well, yeah. Isn't she going to do the same kind of song and dance?
I don't know. I would suspect that the first thing you said is right. You're going to get some kind of an attitude from her. I would have to guess. It'll be interesting to see what her relationship currently is with these two different people, what her attitude is towards them. Obviously, she's already in prison. So, one of the questions I have is, will there be a deal worked out with her? Because, what incentive does she really have to testify at this point? She's in prison for facilitating this murder. She's already had her day in court and lost. And so the question is there anything she can get out of it? And then, of course, you then have the impeachment problem with her, but you're going to have that with her anyway. So if I was a prosecution, I would make use of her because she's the most important witness. She knows the most about this case, for sure. And so you really do want to get her on the stand to at least give her the opportunity to share what she knows. Because I would suspect, I don't know, obviously, but I would suspect that she's not going to be kind to either one of these people, the defendant or the other witness. I could be wrong, but if she comes forward to testify, it's going to be to throw them under the bus, in my opinion.
Of course. So, Florina, you get her on the stand. Your represent testimony moment that maybe the prosecution's concerned, maybe the defense is concerned, maybe the court is concerned. And sua sponte says, let's get this person in here. Nobody wants that kind of mistake made with a witness in the box in front of the jury.
For sure. And this judge has already very strongly reprimanded the defense counsel for violating the rules of evidence. And we didn't see it live on the channel today, so we don't know exactly what was done. But there was the judge is very much on edge, though, in this case, with evidence coming in that's not appropriate. I thought it was interesting, though, that the attorneys, and we only saw a small snippet, so it's possible we just missed this. But I thought it was interesting that there were no attorneys. Usually you're talking to the attorneys about questioning properly. This seemed to be exclusively the witness, which I thought was interesting. But in any event, I think that my colleague is correct about the concern.
Yeah, it was almost like the judge cut out the middleman. Let me just talk to the witness about what the witness cannot tell this jury. I don't know. What do you think about this guy? He's not quite Columbo-esque, but he's a little conveniently forgetful. Jeff, what do you think?
I'm just in shock that in 2022, we have somebody it's surreal, and you alluded to it, testifying to an interview he conducted that is not on tape, that is not on audio or video. I mean, he's actually mocking it, saying that you see that on TV, but it doesn't happen in real life. That is ludicrous. I mean, that is laughably ludicrous. The overwhelming majority of states in the country, if not, I mean, I've seen studies on this. I haven't updated. I didn't think I would have to update my knowledge on this because it's so common now. But I can tell you with assurance that the overwhelming majority of law enforcement agencies throughout the country do tape felony, custody, criminal, suspects when they're being interviewed. So this is laughably ridiculous, to be honest.
Let's go back in, and I hope somebody fixes this caller, because that's driving me crazy. Let's go back live.